Okay, and music. All right, welcome back. Let's look at some of these questions. Repeat the job of the grantor, please. I glazed over that before, but I think that's something that is well worth putting right up front here. We're going to talk about all of the trust positions. I'm no longer the presenter. Okay. We're going to talk about all the trust positions. The grantor also can be called the trustor or the settlor. There are slight differences between the three terms, but for the moment, let's just treat them all as the same. That's who desires to create the trust and who places something in trust, whether that be rights or property or assets. Okay, so in a living trust, for example, which is a statutory type of trust, old grandpa decides he's going to leave his fortune to his children and grandchildren, and he grants his property into trust and names a trustee to administer the trust, and then the whole family is taken care of should he pass away. And it's done while he's alive and moves his assets so they're no longer his, but he still has use of them in that particular type of statutory trust. How long have you been operating trusts, and are you exchanging with other trusts? I no longer use, speaking just for myself, I no longer use my public person, my ens legis estate person. And the exception would be international travel. At some point, I hope to travel other than with a U.S. passport, but at the moment, the extent of my public person ens legis use is international travel, sort of as the original concept of the United States Federal Trust was intended to be. It's for an international face on this continent, and how we interact with other parts of the world, as opposed to day-to-day operations on this land. I've been operating trusts for several years, and both as trustee of others' trusts and have formed my own trusts. How many different kinds of private trusts are there, and that we are going to learn on these webinar series? Okay, that's a great question. We're going to focus primarily on two very similar trusts. Okay, the Private Express Trust and the Charitable Trust. I say similar because my opinion is done right. A charitable trust should be set up like a Private Express Trust in every way, except that if, depending on your charitable purpose, you may be including the general public as beneficiaries. So the structure is very, very similar. The indenture is very, very similar. The indenture we're going to be providing is a Private Express Trust under the common law. And a charitable trust is a few modifications of that. Principally, you could actually pretty much use the same indenture, but it does include a broad array of beneficiaries that are not named by name, and therefore it does pull it somewhat into the public jurisdiction. So we will touch on this again when it comes to specific goals and purposes of the trusts. There are some other uses of it that I think are important. One is what you might call the body trust or the origin trust. That's where you place your DNA and your flesh and blood and brains and all into trust. And that can be a good starting point. There's the Private Express Trust and there's the Charitable Trust.
I can touch real quick on that. We'll also be covering different forms of nominee trusts and different trusts that can be used, not necessarily can be used statutorily, but can also be used outside of statutory. But our main focus is going to be the Private Express Trust under common law. And it's gosh, how do you explain this? The true extent of how many trusts we are actually going to cover under this series is limitless, because the true intention of a trust is unique to every individual indenture. Thereby, there are only certain mechanics that follow the organization of a trust, but the intention, its purpose, its usage, its administration, and its protection is all based on the intention of the party that is creating it and the authority that it dictates to its trustees.
Yep, well said. Eric comments that Ursula, which if you're not familiar with, you might want to look up online. I believe it's ursula.org. UrsulaProject.org, I think. Anyway, Ursula is a fascinating project that I'm involved with. He's saying natural law equals positive law. Well, that's only under Ursula. Only with Ursula, which is really a platform for a new economy, a new world governance, new systems to replace the failing systems. It's a very exciting project for that. In that project, in that new scenario, natural law will equal positive law, and I agree. It's that we're going to see some change and some very interesting things coming forward. Ursula is one of them. Roy, are lawyers legally allowed to practice or give advice on common law? The answer to that is certainly. All of California law, for example, or any state law is the code and statute and any law used in court comes from common law. Okay, it wouldn't exist without common law first. And if you go to the California Civil Code, the first page, it talks about common law and how that's respected as the higher law form and must be observed. Okay, so if you know how to stand on it, you can stand in common law. Okay, it's tricky because the opposing counsel and even the court is going to want to draw you into the code. But common law is enacted law that is in effect in every state and throughout much of the world, and is a higher law form that anyone can stand on, including a lawyer. Yes, absolutely. It's not outside the lawyer's jurisdiction. If you were sitting in a park and a policyman, I assume policeman, but policyman's a good term for it, came and asked you to leave because of some ordinance and asked for ID, would you show trust ID and stay in the park? You're not going to show 14th Amendment citizen ID. So, hey, I'm not going to. It said, would you? Okay, if I were sitting there. So if I wouldn't show a driver's license, passport, state-issued ID. If I were trustee, if I'm operating as trustee of a trust, I will show him trust ID, trust paperwork. The trustee carries a trust folder that has the trust's documents in it, and you would produce something from the trust folder. If you didn't have your trust folder with you, if I were sitting in a park and a policeman came and asked me to leave, I might say, on what authority? Quite frankly. Would I show trust ID and stay in the park? It depends on how badly I wanted to stay in the park. Depends on, how long it's been since the last time I had 72 hours of practice in county jail contracting with the bulls. It depends on a lot of things. I'll say this. Freedom, in my opinion, in this country comes down to whether you're willing to contract with the sheriff's department or whoever might want to pick you up and take you to contract with them for 72 hours. Because if you're willing to contract with them for 72 hours at any time, rather than follow their policy, then you're truly free. If you're not willing to do 72 hours in a very cold, hard cell, then that's how they get you. That's how they get you to conform. to the policies set out in the codes and statutes and carried out by the various police forces. So, for me personally, if I know I'm right, if I know I have rights, if I have unalienable rights that this officer is trespassing on, I would probably point that out to him. And if I didn't care to do 72 hours at the time, I probably would, politely decline to show him any ID, and I'd leave the park. I'd just avoid it. But if I wanted to be there, if it was important to me to be there, then I would stand on my unalienable rights to stand on that land. Okay. Apparently there's a wiki entry on a conflict of laws in the United States are considered differently. Yeah. Oh, yeah. In the United States, notice that term. Everything is considered differently in the United States.
Why is that, Christian?
That's because we're not, most of us, smart enough to operate without the United States.
Could it be because it's a private express trust operating under common law with certain benefits and privileges given to its beneficiaries and controlled by its trustees? And under that Constitution, there are certain standards and practices that are enforced under that jurisdiction.
And if you want to be a beneficiary of it, then you got to let the trustee do his job. Yes, that's exactly right. So, that's well said. So it can be argued that the international banks, this is a question from Darlick, so it can be argued that the international banks can be in violation from the onset of their contract. True?
Could you please repeat that for me?
Yeah, she says, so it can be argued. Why does the presenter keep going back and forth between us? Are you doing that, PJ?
No, I'm not.
I keep saying I'm the presenter, now I'm not the presenter, now I'm the presenter. All right.
You'll have to talk to tech board.
So it can be argued that the international banks can be in violation from the onset of their contract. Talking about mortgages. Is that true? Well, yeah, I could definitely present lots of. I wouldn't even need to present argument because I could present statements of fact that the certain international banks or all of them are in violation ab initio. Yeah, I'm not sure how exactly what she was responding to when she wrote the question, but yeah, I would definitely say that a lot of what the banking cabal does is a violation of my rights. If contract is law, why does our private administrator process get ignored by the alleged creditors?
What contract and what jurisdiction are you attempting to enforce? What portion of the trust are you playing in? It's a major factor in why private administrative procedure chooses not to work. Oftentimes, private administrative procedure has been implemented into some form of public jurisdiction, whereby if you're not following the rules, you're not doing what's appropriate.
Well, and really, what it comes down to, I think, is that most of the private administrative procedure that's going on is against, as he calls them, alleged creditors. It's banks or those who allege we have a debt to them, such as IRS. And when you do a proper private administrative procedure, you've got them. Okay, so they know that. They can't win on the merits, so they try to take it into a lower court law form where they can win on procedure. Or they try to ignore it. I mean, basically, if they can't do anything about it, they're just going to ignore it.
I got to bring up something else too, and this is a great segue to trustees in commerce, another piece that we had put up for homework but didn't get a chance to cover because we decided to move it to a more relevant webinar. But it's the fact of the stance that you take in court. What stance are you taking? Are you taking a stance that allows you to look dual-minded to the judge? Or are you taking the stance of a separate and autonomous trustee acting in its form to protect its res as a third party or real party in interest? Or are you entering a motion to dismiss because the trust has been questioned or is being attempted to being brought into this jurisdiction. There's a little piece that Carlton Weiss talks about covering that, and it has to do with the stance. And I'm just going to read this real quick because we have a little time. Sovereigns were nothing more than cestacate trusts, beneficiaries. Secured parties were nothing more than people with split personalities reflected in a commercial recording. And we're going to cover that in a few webinars. Even though I understand where they went wrong, the way they went about it was so rife with contradictions, you got the sense they had a screw loose. They couldn't really be helped because they wanted to be respected as creditors when it suited their needs, yet they wanted to be absolved of liability like wards of the court when the pressure was too much. So that's just a little piece to explain a little bit about that. It oftentimes has to do with your stance as an individual. What are you representing? How are you representing yourself? And are you walking in as, in an illegitimate capacity? Are you attempting to be ward when it gets too tough? And are you attempting to be sovereign when nobody's challenging you? So sovereignty is a lot. And to protect that sovereignty, well, people have gone to great extents. In fact, the U.S. has gone to spending over 80% of its entire funds on defense for the purpose of keeping its status as a sovereign.
Or for fueling the world economy. Brandy asks, Constitution was to shift debt to a third party? The answer to that is a little complicated. Yes and no. It did a number of things, and there's a whole history of the debt shift and how we gave up our rights for debt. And there's we could do a whole series of seminars literally on that topic. So I'm not going to, it's not the aspect of the Constitution that we're focused on here. I would say that if you don't know that the United States is a bankrupt corporation that owes everything to the international bankers, and that 100% of your income taxes go to the Federal Reserve Bank for distribution to international bankers, then you might want to look into that. It's a great question, just not the focus of this. It's not our mission here. Yeah. Can you share the difference between state and nation, if there is one, JPS? And the answer is yes, I can. Next question. What I want to do with that, she didn't ask for an answer. She just said, she asked if I could. What I want to do with that is add state and nation to the homework for next time. Let's add those definitions. Everyone else can answer that question for us, with us, and let's do that next time.
That's a good idea.
Does that also mean that the protections of impairing contracts are also not respected? Not sure what he's referring to, and this is, we didn't catch this in line. Does that also mean that the protections of impairing contracts are also not respected? Oh, I think it's probably my comment about courts and opposing counsels trying to gloss right over the protection of contracts in the Constitution. Does it also mean that the protections of impairing contracts are also not respected? If I'm interpreting the question right, it's saying, is there not respect for contracts through the court system or whatever? And the answer is, quite often there is not, when they can try to lean on procedure instead. It goes back to Min's question about private administrator processes getting ignored, and instead, they just take it into court and try to get a procedural remedy. The code has made it quite easy for hack lawyers to get procedural remedies, to go in on procedure and ignore the facts and get their procedure, get a remedy with their procedure. And that's their preferred way of doing it, because it's what they know, it's what they're taught in law school, it's what our system primarily operates on. It's very rare that you get a common law court hearing. It's very rare. It's even rarer that you get a common law jury. And these lawyers. I mean, so many of them are hacks. I mean, I've dealt with an awful lot of them in the last few years regarding mortgages and such, and they don't know anything. It's amazing how much there is left out of law school. They're grooming debt collectors. That's really what it comes down to. They're grooming glorified debt collectors. That's where the business is. State citizens are kings, says Brandy. U.S. citizens are subjects. Absolutely. Yes. Sovereign versus fiction. Subjects. Yeah, totally. They're creatures of the law. All right. Is there source material that supports the trust as being a natural person? Yes. Any definition from Black's to Bouvier's to Wikipedia will show you that a private express trust is a natural person. Also, I mean, certainly Bogart's on trusts, or I mean, any reliable handbook of trusts, several of which are in the Blue Library right now on our site, which is the public library. You can look that up.
Also, I can give, just for example, the small paragraph that I read from Weiss has over 5 citations in it of case law, dictating and explaining the term natural person and its use thereof in this. Clues versus Jameson, Burnett v. Smith, Brigham v. U.S., Waterman v. McKinsey. These are 4 of the 6 that come right off the top of these case law references. And these citings are so important because this is why we feel that this is a great reference book, because the guide has many citings that really back what is being said. So it's very powerful.
Cool, yeah. Liot asks, what is an alternate to a birth certificate, driver's license, passport, etc.? PJ, why don't you take that one? I've already touched on it.
What is an alternative? Well, this is all determining on what contracts you wish to enter yourself into. Now, my personal opinion is that the contracts that I've already entered into, I am responsible for, and therefore I will manage them accordingly, such as my driver's license, passport, birth certificate. These things are all there, so I must manage them appropriately. In the future, when I was to have a child, there is an understanding of what the birth certificate is. It is a certificated security. It is a representation of a security. A representation. So what we would be in a position to see is if the private trust, and this is just a theory, okay, I pose this to you as a question. If the private trust known as the United States can create its own certification of chattel for the purpose of securing collateral, securing a debt, using that chattel as collateral to secure a debt, could not the private express trust operate under the same circumstances and do the same thing? And that's where I'll leave that.
Cool. I might just add to that in operating in trust, you can have these other things too. You can operate your public trust too if you want to. You could have a driver's license if you want to accept that benefit and privilege. You could have a passport for international travel or for identification purposes.
And so we're clear. I have a right to travel without any license or necessary paperwork. However, if I'm driving a commercial vehicle and I wish to do business in commerce in the state, it may benefit me to have a driver's license at that time. So operating, it's really about what hat are you going to wear? Just like in the old, I think it was old Andy Griffith. He was the sheriff and he was the constable. He was also, I believe, the treasurer. He just put on a different hat whenever it was time. And it's the same situation here. If you can consciously understand that you are separate of the commercial entity that is the taxpayer identification number, then you can understand that you can recreate yourself in the likeness of yourself into a trust as well, which is the opposing fractal of what that is. You have a trust up here creating a fiction, and you have a living man here creating a fiction as well. The natural person creating a fiction, the natural person creating a fiction. The fiction that you create becomes a natural person under certain jurisdiction too. So it's very interesting how that fractionally continues.
It is conceivable that you could use a driver's license, and it is also conceivable that you could have your trustee folder, and you could make it abundantly clear to a police officer that pulled you over by the roadside, for example, that you are operating outside the United States federal jurisdiction, that you are not operating as a 14th Amendment citizen, that you are a natural person on trust, operating as a trustee on official trust business, and you technically don't need a license plate, a driver's license, or a car registration of any sort. Now, in order to operate that way, you need to get all your ducks in a row, and we could do a whole seminar on that.
We are.
But basically, what's that?
I apologize for interrupting you, but a portion of one of our future webinars will be covering the concept of right to travel and the aspect of trust and using trusts and the property of the trust to travel outside while in the States.
Yeah, we will touch on that, and I think it might also be a future webinar in itself, not in this series, but in the future. I think it's a good webinar topic. It's certainly one that we would consider doing. There are a lot of moving pieces to that. You need the manufacturer's statement of origin of the car. You need the license plate to not be a California standard plate. You need to not present the driver's license and not have one. You need to rescind it. There are a lot of steps to that, and they all need to be in place to be airtight with it. And then you're still going to have to be willing to do 72 hours if the police officer that pulls you over doesn't agree with what he sees. Now, it won't stand up in court. What the officer does to you won't stand up in court, but the fact that he doesn't know the law is something that could work against you at an inopportune moment.
It is a common issue. It's very common. To cover this same topics that we'll be covering in the future, I just received a question. Will you be covering the three trust approach, quote unquote, the private trust, the pass-through trust, and the public entity interface? And the answer is yes, to some extent. We will be covering lien rights, we'll be covering security agreements, and we will be covering the relationships and bonds that interact between trusts. And we'll be covering that topic in a roundabout format. Our goal is not to create these items or to give them to you, but rather to educate you to form them yourself. So hopefully at the end of this, you will be knowledgeable enough, all of you, to form the relationship that's necessary between your private trust to your pass-through trust, and form the relationship between your pass-through trust to your either LLC or private corporation or nonprofit or not-for-profit or religious
or public trust.
Or public trust, yes. So the answer is yes, but we will be covering it in a colorable sense to allow you to make your own decisions in the future as to how your relationships will be governed between trusts. So.
Good. Robert says, how about getting out of the marriage trust with the state? I assume what he's saying is, how do you end what you've already, how do you undo what you've already done if you're married? And the answer is that a divorce is the answer, and it requires a judge. There may be another way. I've never looked into it. I I took the divorce route, but for other reasons. um,
Well, this is something I'd like to touch on real quick.
go for it.
What we are covering here are not aspects of how to backtrack. These are aspects of how to live from the get-go. In terms of transferring assets, in terms of marriages, in terms of protecting res, in terms of traveling, all of these will be discussed from the origin of its best form to do it from, and we will try and avoid the conversations of going backwards to attempt to get where we're at. Always remember that it's not either or, it's and. What you have existing now is existing now no matter what you do. What you can create in the future is an autonomous vehicle for your own legacy or for the legacy of others. And ultimately, it's important that you distinguish those factors, that in repairing and replacing and attempting to backtrack, there are 1,000 ways to skin a cat in any situation. However, in this series of webinars, we will be covering from the origin how to create to ensure that you are moving forward from there. For example, the MSO to a vehicle before you were to purchase a vehicle, not the vehicle you already own that you have a lease on that is registered with the state of California and has insurance through Progressive. We're talking about an MSO-owned vehicle, which normally has to be ordered sometimes from out of the country even, and that MSO being placed to a trust, a bond being placed by the trust with legitimate assets to back it, and a private trust identification card showing, and also trust documents showing that the trustee has authorization to transport the res to wherever it needs to go, the res being the vehicle. So these are things that we will cover, but understand that we're attempting to align with what is always going to happen, not what we have to clean up. What is always going to work for the future, not what we have to clean up and make right. We're big fans of saying, hey, everything's perfect the way it is. I was born with a birth certificate for some reason. My parents didn't damn me for doing it, so I have to have a reason for using it, and I'm not going to expatriate or any of that nonsense because I have the ability to contract outside of that entity anyway. So there's never a need to rid yourself of those things, only to progress in a different mode. So
Alan asks, how do you leave the public trust from the United States? How do you leave the United States public trust?
That's a
and
great
how do
question.
you travel?
Follow me after that.
Yeah, I know, isn't it great? And how do you travel once you leave the public trust? Do you still need a U.S. passport? And if you want to operate as a non-citizen, non-national, non-U.S. citizen, non-national, and instead state citizen, there is in the U.S. code, there is accommodation for that. You leave simply by a declaration of non-citizenship, by relinquishing your citizenship. And before you do that, I hope you know what you're doing to set up your citizenship with the American Republic through one of the states, one of the several states. And it can be done. It is a form of expatriation that is done by, I know a number of individuals that have done it. There are separate courses and seminars and there's a whole thing on how to do that, and it's something worth considering. Our focus here is not to do that. Our focus here is to create a separate private entity that can run in parallel to that. Is that you could use as much of that public trust as you want, and as little of it as you want. I personally choose only to use it for international travel. It makes my life easy crossing international borders. The rest of the time, it makes my life miserable to use it. Well, not miserable. I was pretty happy even when I operated under the United States Trust, but it does not behoove me to present the fictitious ens legis person within the United States only on crossing its borders internationally.
That was good.
Thank you.
Do we have more questions?
Yeah, I'm trying to get my. There we go. There we go. Darla says, why would I produce ID without jurisdiction? We're traveling at the speed of liquid crystal.
That's a well placed statement, and that is a very good statement to make. We learn in certain aspects of dealing with federal policies, federal and state policies. We find that it's not even necessary to identify yourself if you're in a position of not being I guess, being approached and charged with a crime. If it's investigative or if it's in any way interviewing, you have all the rights in the world to legitimately plead the fifth, because any single word you say may incriminate you in the future, including what I just said.
Michael's got an interesting question here. The Constitution protects the right to contract, and it also says there will be no titles of nobility or fiat money. But de facto has nobility titles and fiat money. Does that mean it also abridged the right to unlimited contracts?
That's an interesting concept. Say that again, will you, please?
The Constitution protects the right to contract. It also says there will be no titles of nobility or fiat money. But the de facto government has nobility titles and fiat money. Does that mean it also abridged the right to unlimited contract?
I would say that it, in its corporate stance, may have attempted to, but all of that is null and void, as you can see in the Constitution, because it states right then and there that that de facto government has created a law that is being usurped. It's a law that's unconstitutional. It's a form of law that doesn't match the articles and bylaws of the business that we are working out of. And so therefore, if it's not challenged, then it may just stand as truth. Anything that stands unrebutted stands as true. So I believe that there are several organizations, including one we won't mention anymore, that take that as an opportunity to claim that there may in fact be an abridged sense of rights, an abridged right to contract, whereby they feel that they do have right. And once again, it falls into the category of he who fails to assert his rights has none. Hence, it is by the protection of the trustee to the trust that the trust is unpierceable. It is the trustee that makes it so powerful. It is not the trust documents itself, because if the trustee fails to appear, well, the trust documents fail to appear, and any controversy or case falls under a constructive trust, whereby the judge determines who is trustee, beneficiary, and grantor.
If you look up de facto, which I think we did we? Yeah, we
yes,
did, right?
We did.
De facto has, at least in Black's law, it has the in the definition that it's illegal or unwarranted. So, we've got a situation right now where we voluntarily let things happen in an illegal, illicit sort of manner, and there's all kinds of stuff going on that the founding fathers never envisioned, and that are not, strictly speaking, constitutional. But the people became persons under the 14th Amendment, and thereby gave up their rights in exchange for benefits and privileges. And when we all essentially did that, everyone who has a social security number certainly did that, the rules changed, because now we're operating out of the Commerce Clause. Everything comes out of the Commerce Clause of the Constitution, instead of the larger body of rights that it protects and the limitations that it places. So therein lies the problem, and that's what makes the de facto government, and provides the opportunity for us to all discuss it and get beyond it. Rick Gilliam asks, do you like Gilbert's trust book? Yeah, Gilbert's is good.
Okay.
Bogart's is good. Uh, Bogart's and Gilbert's are really they're really authoritative law books on trusts, and well worth looking up your trust questions in. Weiss's concise trustee handbook, on the other hand, is more of an explanation of stance. Gilbert's and Bogart's are they're straight up understanding of trust law.
And case law, yeah.
What's that?
And case law, major case law that they represent, both statutory and non, I believe.
Yeah, well, they get into all of it. I mean, it's they're smart interpretations of the trust law by smart people. Um, why is common marriage not recognized in many states? I assume that's common law marriage. Um,
There's no licensing value for the state. There's a revenue that comes from issuing licenses. And it's a huge amount of revenue that the state receives.
yeah.
So why would they recognize it if they didn't issue it?
Well, they have this great thing, a license. It's like, you want to practice real estate, you got to get a license. No, you don't. That is it. That is complete garbage. You can practice real estate without a license. So you need a license to drive a car. No, I don't. So these things, they put it forth in a certain way because they want you to be subject to the codes, and therefore vote with your feet to appear in behind the wheel as a 14th Amendment citizen subject to those codes. So they issue a license, and you voluntarily take it. And the same with a marriage license, and the same with you name it. Anything that's got a license involved. The bar members.
I'd like to say something about licensing as well. There is the purpose of the application, the purpose of standards and practices. For example, the driver's license. I personally feel that many forms of licensing are important because it creates a standard and somewhat of a data integrity board to ensure the balance and standards of the whatever is being governed, whether it be the rights of driving or safety of roads. I'm using the driver's license as an example. The reason there is a test and an approval is to ensure standards, to ensure that standards are met and that there is data integrity that is being met and that everyone is equally safe on the road, and also that their vehicles are covered for damage and tort or amongst other things. And that's, these are major factors that come into, for example, licensing. But if when you receive your insurance bill from the state of California Department of Motor Vehicles stating that you have to show proof of insurance, it states clear and presently on there that the state of California will accept a $35,000 bond. So, it's very clear that you can operate under certain circumstances while meeting the standards that exist for the public and still operate privately.
Absolutely. The requirement is that you have evidence of financial responsibility, which can be your own bond, drawn off of your birth certificate bond.
Uh-oh. We're drawn off of a trust asset is what we would be better to talk about.
Okay. Not that couldn't be a trust asset.
Yeah.
All right. What about an ID? This is Gabriel's question. What about an ID with an affidavit of who you are versus the all caps name with witness signatures or notary seal?
Yeah.
Yeah, you could create your own ID. There's nothing in the law stating that your ID has to be property of the state or the federal government. And in fact, all of your typical IDs do remain the property of the state or the federal government. But you could have ID that is your property and indicates very well who you are. And how you create that as a trustee in a private express trust is is essentially the trust issues it. So it identifies who you are and as the trustee of the trust.
Once again, I think we're talking about a form of data integrity, and the trust as a private entity has its right to give you the authority of trustee and to identify you as trustee. Therefore, a picture identification issued by the trust authorizing you to act on behalf of trust affairs could easily be used as an identification card if you were under the right circumstances driving a vehicle that was not registered to the state or that had insurance with the state, and things of that nature. Ultimately, the trust is who identifies you, just like the state trust is who identifies you when you place in an application for an identification card. The standards and practices in data integrity is based on the reputation and the standards of the state itself, which, since it's larger than the people often will back as the standard. But it's voluntary. It's all voluntary by every individual that has accepted it as a standard.
Think of it this way. The United States Trust we use as an example because it's the big one, right? It's a private express trust under the common law operating on the land of America. Okay? If you and within that there's driver's license requirements. Okay? If you exit that and you operate in a different private express trust under the common law on the land of America, then wouldn't you have trust documents that are the property of the trust, just as the driver's license is the property of the state? You'd have the trust documents that are the property of the trust that identify you in the same manner that grant you privilege to operate that vessel on the roadways. You're creating an equivalent trust. So have equivalent documentation and standards for public safety. So, you're fully insured. The car is in good working order. It doesn't have a headlight out. It's fully insured by self-insuring, probably by bond. And the title is owned by the legal title is owned by the trust, not the state. Because when with a license plate situation, with a pink slip for a car and a license plate, the state has the legal title and you have equitable title. You have the use of the car, but you don't actually own it. You get to pay for it. You get to pay for all the repairs. You get to use it, but the state owns it. And if you don't believe me, just watch how easily they tow it. But they have no right to touch it.
You can also ask about the MSO at the state DMV, and they will tell you that they destroy the manufacturer's statement of origin and replace it with a title under the state, meaning that they have titled their own property as state property, and that property is now registered state property with you as beneficiary.
And you have a certificate of that title. You don't have the title. You have a certificate, sort of like your birth certificate is a representation of the existence of the birth certificate bond.
And,
So
I'm sorry to interrupt you. Just so we're clear, the idea of the DMV, all of those aspects, they're all, once again, forming a standard that can be formed. In fact, it's a great example of how to form your own standards to ensure that you are operating safely for the public around you when you are operating privately. And this is one of the main, things that I feel that a lot of individuals have glazed over in these topics is operating safely and securely for the benefit of the public while still operating in private, because that is the true integrity of the trustee.
Darla asks, does your folder ID your indenturement? If I'm interpreting that right, does the folder contain it, or would it have the trust indenture in the folder? And the answer is no. Trust indenture is private. What you're talking about in having it in your trustee folder is
I see
is
what you're talking about.
if I'm at least if I'm interpreting this question right, what you're talking about having in your trustee folder is specific items and not necessarily including your indenture. At least you wouldn't pull it out and show it to anyone. Yeah,
You may
that's
have
private.
You may have a copy of the indenture with you, but it is definitely not necessary when traveling to do trust business into the state. And when traveling to do trust business into the state, all that would be necessary is a certificate of trust and the appointment and authority of the trustee dictating that they own the right, or that they have the right to control the property that is owned by the trust.
The right
And
and obligation. And
yes,
obligation. So that your point is that you're traveling you're traveling in on trust business, and everything that's on you is trust business related, and it is a private express trust outside the United States.
and just so we're clear, the identification, it doesn't even belong to me. It belongs to the trust, just as the driver's license belongs to the state and can be revoked. So if we fail in our duties as trustee and we breach the trust, it's very easy for the trust to revoke its trust identification card and remove the incidental benefits of trusteeship that go along with controlling and doing business for the trust.
We're gonna do 8 more minutes here, I think. It's going to be 9 o'clock, 12 Eastern. I think it's 3 hours is plenty. We'll take as many of these questions as we can in the next 8 minutes. Is indenturement and intent blended? Darla asks. And again, interpreting this, I would say intent is what is memorialized in the indenture to carry out the intent.
Well said.
Can a private express trust, this is Sam's question, can a private express trust be automatically recognized in other countries via the Hague Convention on the Recognition of Trust?
Just so we're clear, I'm not sure anything is automatically recognized. It falls right back into the maxim, he who fails to assert his rights has none. God does not go around showing people that he is God. And the ultimate faction here is it is only recognized in places that are necessary to have it recognized. And ultimately, the trust itself is a private action that should only be brought up when questioned in the integrity of the trustee's actions. Should, for example, should the trustee be pulled over, it is automatically dictated that this is a private contract. You show all of the documents to the officer. So in an international court, this actually falls, if I'm not mistaken, under under Article 3 court, a basic equity court. It's a court of equity that can only see this, or a common law court, a constitutional court, forgive me. So does it get internationally recognized automatically? No, because that would dictate that Palestine is internationally recognized, and they're still only looked at as a principality. They're still not even a nation. So when we think of aspects of operation, the first question would be, do you want it recognized internationally by the Hague? Because part of being a sovereign nation is having your own land, your own fortified army to ensure that that land is safe, and if you have any invaders, that you can ward them off. And it also dictates having your own mail treaty, postal treaty as well, with the UPU. So I wouldn't go as far as to say yes, but I would say if necessary, it could easily be recognized for certain purposes.
In the Blue Library, there is a link to the Hague Convention, including foreign trusts, and I would suggest that you start there. Michael's pulling it up.
And that's real quick while you're saying that. One of the sources we will be covering in the future is the International Treaty on Trusts, the Hague Convention International Treaty on Trusts. We'll be covering a little bit of that as well in the future. So,
see this Hague Conference on Private International Law, International Commercial and Finance law, including contracts towards securities, trusts, and recognition of companies. Yeah. So I would say that that's a really good resource to find the answer to that question specifically. Barry asks, will you talk about how to structure a trust so you can take care of all usual day-to-day expenses through the trust? Yes, we will.
Yes.
He also asks, when we make a sample indenture available, and the answer to that is probably just immediately before the indenture workshop, which is the final and probably longest webinar. There's good reason for that, quite a number of them, but we want to make sure everyone gets it, but we want to specifically go through it and get the understanding of it in that time frame. So we'll give it to you then.
Also, real quick, I wanted to state something on the affairs of operating day to day. The affairs of operating day to day rest solely on your ability to account. Your accounting is very important because your balance has to balance zero and the trust balance has to balance zero at the end between the two of your contracts. So ultimately, when you are exchanging trustee compensation for certain benefits, or you are using your own trustee compensation, or you are keeping track of items that you are going to be remunerated on by the trust, it is important that you keep a proper accounting of that so that you can ensure that all money that is being spent from your pocket is the trust's money in advance to you by way of a liened contract with your trustee compensation held as collateral in the security agreement.
And we will go into that later. Gabriel, at the end of the day, it's all about jurisdiction. That is determined by the hat you wear at that specific time. That's absolutely right.
100%.
Absolutely right. Michael, can you please speak to the significance of G10 flying a U.S. flag? Oh, yes, I can. I'm just a bit confused about invoking any flag if the trust is in private jurisdiction.
Yeah, please
Okay.
expound on Title IV flag, please.
First of all, that is not the U.S. flag. Okay? That is the United States of America flag. That is the Title IV flag. You can tell because it's the easiest way to tell is it's 1 by 1.9 in dimensions, as opposed to 1 by 1.6, I believe the U.S. flag is, and it is borderless. Title IV flag invokes a certain jurisdiction that is American, not 14th Amendment citizen, not United States. So, great question, but there's your answer. We are invoking. Yeah, go ahead.
This falls into the realm of admiralty, whereby as a private vessel, we wish to fly a flag to ensure who we are in allegiance with and who we are protected under. And when we are protected under as a state citizen, under the protections of the Constitution, then that is what we wish to invoke. If we wish to invoke some other form of international treaty, then that is the flag we will fly at the time. But the purpose of flying the flag is we are, for lack of a better term, in international waters when operating. And until we, through minimum contacts, contract either unilaterally or by admission with any state or United States contractable citizen, you're entering into a new jurisdiction. So it's letting people know, hey, look, we're international, but we're flying a flag. We're flying a flag that dictates what we what we pledge ourselves with.
Right. It is the flag of the constitutional rights, okay, as opposed to the flag of the U.S. corporation, which came later.
So if we were claiming the allegiance of Istanbul, then we would have the Istanbul flag on there. If we were claiming the allegiance of the federal government in terms of its military stance, then we would fly a gold fringe flag. But ultimately, that Title IV flag dictates that us as civilians, that is our military. We are the people that control that military. And by flying that flag, we are recognized as individuals of that nation state to ensure that we are protected. Once again, this is the what hat do you wear and where are you operating from and what contracts are you getting into. Every word you speak with any individual is a contract. It's very powerful. Even I myself trip over my words, and it's very important that we pay attention to our intention and the way that we speak these different topics.
In short, Michael, the flag is the state citizen flag, not the United States citizen flag. And if you look back to the hierarchy of powers, that's where we want to be. That's where our jurisdiction is. Alan asks, do we need an EIN for the private trust to do business in public or open a bank account? The answer is no, and yet you may want one. It depends, and the answer is a little more complicated than we're going to get into right now, but we are going to cover that and the options available. Usually a multi-organizational structure is what you want, something that does banking in the public, something that does not, and they're linked by private contract.
So well said. That's very well said, Christian, and that's really it. Once again, the intention of the party is the soul of the instrument, and not all trusts are going to need EINs, but certain trusts or certain organizations may, and it's going to be the relationship between those, the liens, the security agreements, and the aspects of that really determine what's going on between them privately. So not all of them need EINs, but some of them may be useful to have. So.
Okay, we've come pretty close. It's 9:02, pretty close to, and we've answered all the questions as far as I know. If we didn't get your question, if we missed it this time, simply ask it next time. We'll get to it. We're not avoiding any. I tried to take every single one of them. If I missed it, I apologize. This has been a great 3 hours, so I think the questions have been good. I look forward to the next one. I did not mention when I opened up today that the scheduling of these is going to be about 2 weeks apart, although I have a conflict in 2 weeks from today. So it might be 2.5 weeks or 3 weeks to the next one, or we might put in a guest speaker in the meantime to touch on some different topics, and then we'll pick up after that. We'll figure that out. We'll get the information out to you. We'll do our best to give you as much notice as possible. The reading for the next webinar is already up, as you've probably seen in the Red Library. And if you get through that and you haven't gotten through all the additional suggested reading for this one, I'd suggest you go back and read that too. So it won't be a week from now. It might not even be 2 weeks from now. But we'll let you know as soon as we know, and we'll probably try to map out a schedule, at least a loose schedule, I would think. But it's been challenging for me because I'm a single dad, and I've been trying to figure out how my summer lays out. I've finally got it all sorted, and it involves a lot of travel and camping and stuff like that, where I won't have ready computer access. So we will get it to you as soon as we know it. And please let us know if you have any problems, as several people have so far with the website, and give us some feedback on this. Do we have a poll for how Michael was putting together a poll for how this call went technically and etc.
Yeah, I wanted
we appreciate
to
your feedback.
We got a couple of little bits of feedback, and we thank all of you that did give us feedback, and we do appreciate more. This was our first interworking with GoToWebinar, and we had a couple of little faults here and there. I had an actual computer fault, so I just want to thank you all for bearing with us on that. In the future, it will become very minimal, and we do ask for those of you that were having difficulty getting on, please understand that the webinars will always be autonomous of the site. You will receive an email somewhere during that day, whether it's a few hours before or at the latest an hour before the webinar. And of course, you will have plenty of time in advance knowledge of when this is going to be, similar to how we did it now. We should probably have a date within the next few days to give to you. Please, if you have any other issues or user interface issues, please don't hesitate to let us know. And also, we ask that you please get familiar or more familiar, because a lot of you seem to have done just fine. There was only a handful that had difficulty. Get very familiar with GoToWebinar, because we will be using GoToWebinar for the duration of this series. And I think that's all I have to cover for that. I just want to thank you all so much for supporting us and being a part of this. We feel very blessed to have created this and to get you to interact. And it's been a great opportunity, and we hope to meet all of your needs and provide you all with a great opportunity to learn and a great opportunity to flourish for yourselves after this. So.
And it's been a great experience reconnecting with people that I hadn't talked to in a while, and meeting new people. So we look forward to getting to know all of you.
Yeah, that's another thing. Thank you all, those of you that know us personally and are supporting us. For some of us, we haven't reached out to you in several months, and you supported us as if we speak to you every day, and we just want to thank you for that. We hope to return that same kind of blessing to you someday. So,
And on
lots.
that note, God bless and good night.
All right. Thank you all. Good night.
Cheers, everyone.
Cheers.